And I'm required to make monthly visits, but it appears as if they've moved without notification. So I'd like to make a police report.
Okay, is it the address here on Elm Street?
Yes.
All right, yeah, that's in our stations area. And you went to location already today and it was empty?
Yes, it was empty.
It was empty? Okay. Is the child with their mother?
Yes.
And why would you need a police report?
Because the court has custody of the child.
Oh, okay. Okay, you know what? Let me check with the watch deputy really quick and I'll be right back with you.
Okay, thank you.
No problem.
Now, just as a parent has the right to report a missing child, a DCFS social worker representing the court has the same privileges. If the court places a child or children in the care of the parent under the supervision of the court, and the parent does not comply with DCFS rules and procedures, they are in violation. Now, at the request of the DCFS representative, a missing persons report must be generated by the officer.
Hello, I'm Deputy Hohenhaus. I understand that you need help with a missing child.
Yes, thank you for your assistance. That's the minute order with the location of the last residence and the name of the child.
Okay. Deputy Nix will get some more information from you and he'll get the process started.
That's great. What I need is an investigation started regarding the incident with the related case numbers.
Okay, yeah, we can do that for you. Once the details are clear, we can do that.
Okay, great. Thank you.
To clarify this point, let's revisit a definition from Penal Code 277K.
Abduct, to take, entice away, keep, withhold, or conceal.
As stated, if a parent prevents the court-ordered DCFS worker from contacting the child or children by any means, they are in violation of Penal Code 278 and 278.5a. Now, before you can determine whether a crime has taken place involving abduction, it is important that you establish the existence of custody orders handed down in dependency court. If they exist, care must be taken to ascertain validity of the document.
I know it's Wednesday.
It's not your day. Your days are Fridays and Sundays.
I was in the area and I wanted to come by and say hi to the children.
You could have given me a call to give me a little heads up.
Let me just come in for a second and say hi to the kids.
I should have let you see them.
Or could I just come in for a
No,
second?
you can come back on the weekend. You didn't even call me to let me know that you were coming here today.
3 hours
How are you doing? What's going on here?
He has no rights here. This is my house, and I don't have to let them go. He is a jerk, and he doesn't care about anyone but
himself. She's turning them against me. It's ridiculous.
Okay. Whose house is this?
It's mine.
Okay, and whose children are those?
They're ours, officer, and I want to see them, and she won't let me.
Let you? You can see them as often as you want, as long as you pay your child support.
Hey, you're acting like this is a fee or something.
Listen. You have to, just like the courts say you do. No pay, no play.
Come on, they're kids. Don't abuse them like this.
Oh, okay. Let's see if we can resolve this. Let's step back a moment and see what we can work out.
I'd love to resolve this.
Okay, give me a moment. 48 King 1, what's your ETA to Greenleaf?
Here you go, sir. It's all there.
Okay, give me a moment. I'll discuss this with my partner. It looks good. What do you think?
Yeah, it's got the proper date. It's got all the signatures. It's got the seal. But what does it say about the visitation dates and times?
It's all right there. She's in compliance.
I think you're right.
Well, sir, it seems that you're only allowed to see or visit your children on the first and last weekends of the month in an arrangement with your ex-wife. According to court documents, today's not that day.
Well, no, but I live 3 hours away in Apple Valley, okay? And I was in LA, so I thought I'd stop by. What's wrong with that? You know what I mean?
I understand. But again, according to court documents, today's not your day to visit, and she doesn't want you to visit.
Oh, come on, sir. It's not like I'm taking them. They're my kids. I have rights.
No, you don't. You lost those.
Hey, shut your mouth, woman.
Look. Again, according to the documents we have to adhere to, today's not your day to visit. If you want to get it changed, you have to go to court.
Okay. I'll think about that. Gentlemen, is there anything that I can do so we can make this work? Please.
I wish there was, but we have to adhere to the court document. And I can only suggest to you that if you want to get it changed, you have to go back to court to do that.
All right, great. Another trip to court. Thanks a lot.
All family court orders should be examined carefully to establish if they have been terminated or modified by a new order or have been tampered with. Generally, a more recent issuance date will have a greater chance of validity. The areas that should be checked are a court seal, a custody order filed with the court as indicated by the date stamp, the date the order was issued, the date the order expires, the signature of a magistrate, the conditions as stipulated in the order, including dates, times of visitation, and location.
Now let's take a look at the types of custody arrangements you may encounter in the field. There are two categories: sole custody and joint custody. Let's start with sole custody. There are three types: exclusive, sole physical, and sole legal. What is exclusive? An exclusive custody order gives one parent primary physical control of the child. In other words, the child is with the parent, living or staying, and has the exclusive legal and physical rights and responsibilities for the child. Next, let's look at sole physical custody. A parent may be granted exclusive physical custody without exclusive legal custody. Here, the child is living or staying with the parent. However, they do not have exclusive control of decisions toward the child's rights and responsibility. Now, the last of sole category is sole legal custody. Conversely, a parent may be awarded exclusive right and responsibility to make decisions relating to the child's health, education, and welfare. The difference here is the child's rights and responsibilities are controlled by a parent that is not present at the location. Going further, joint custody takes on another four possibilities: pure joint, joint legal, joint physical, and non-parent. Pure joint custody. Under a pure joint custody plan, neither parent has sole physical or legal custody. Both parties have authority to control and supervise the child, and the child's physical presence is shared. Joint legal custody. Now, joint legal custody means that both parents share the rights and responsibility to make decisions regarding the child's health, education, and welfare. Joint physical. A joint physical custody award means each parent has significant periods of physical custody. Non-parent custody. Subject to strict statutory standards, custody may be granted to a non-parent, such as the Department of Children and Family Services, a grandparent, or an older sibling.
Hello, Deputy.
How you doing, sir?
I'm the one who called.
Okay. What can I do for you today?
Well, it's kind of difficult to explain, but I sent my kids to their mother. She lives in Arizona. We're divorced 3 years now. Per the court, she can legally keep the kids for 1 week. But it's been 3 weeks now, and she says she's not going to return them. I mean, this is crazy. I have rights regarding this, don't I?
Do you have your custody paperwork with you, sir?
No, they're at home. You need to see them before you can do anything?
Well, first off, you do have rights even if she is in Arizona. However, we'll need to see the paperwork to establish the custody issue with the kids. So if you could bring that paperwork in from home to the station. Do you know where the station is, sir?
Yes.
Okay, bring your paperwork, custody paperwork in from the station, and they'll help you file the needed reports.
Okay, was this considered an abduction? And will she be arrested?
Well, usually it's just a disagreement between adults. However, child abduction and concealment is a felony, and she could go to jail.
Okay, thank you.
All right, before we part ways, if I could see your driver's license for your name and date of birth, please, just for my paperwork.
Okay.
Thank you.
When encountering a situation where a parent or family member lives out of state and refuses to return the child after their visitation, California penal codes still apply. The penal code that deals with out-of-state parties is 279. 279 states,
A violation of Section 278 or 278.5 by a person who is not a resident of or present in this state at the time of the alleged offense is punishable in this state, whether the intent to commit the offense is from within or outside this state, if any of the following apply.
A, the child was a resident of or present in this state at the time the child was taken, enticed away, kept, withheld, or concealed. B, the child thereafter is found in this state. C, the lawful custodian or a person with a right of visitation is the resident of this state at the time the child was taken, enticed away, kept, withheld, or concealed.
If the criteria is met and the out-of-state parent is in violation of California law, it is important to contain Penal Code 279 in your report to aid investigators and other agencies with the process. In situations when the subject and victim travel interstate, the FBI can assist your agency. This is also true for international abductions and concealment.
Law enforcement officers may encounter situations in which child concealment by a parent or legal guardian is justifiable because there is a reason to believe the child is in danger. This exception is covered in California Penal Code 278.7, subsections A, B, and C.
California Penal Code 278.7a states, Section 278.5 does not apply to a person with a right to custody of a child who, with a good faith and reasonable belief that the child, if left with the other person, will suffer immediate bodily injury or emotional harm, takes, entices away, keeps, withholds, or conceals that child.
In subsection B, the law specifically includes the suspect who has previously been a victim of domestic violence. Subsection C spells out the steps that the suspect must take in order to be able to claim this affirmative defense.
It is not the officer's responsibility to convene court to determine who should have a right to custody. The officer's role is to ensure the safety and well-being of the child. Officers should always separate the issue of custody from the issue of abuse. The officer must reasonably attempt to determine, based on observations, interviews, and other evidence, whether or not the claims are valid. Inappropriate or unauthorized actions on the part of the officer can not only jeopardize the well-being of the child, but also bring about liability concerns for the officer and the officer's agency. The officer's primary responsibility is to the safety and well-being of the child.
When an allegation of danger to a child is made, the officer's investigation must be thorough. California law authorizes a law enforcement officer to take a child into protective custody under certain circumstances.
278.6a states, 1. It reasonably appears to the officer that one of the involved parties is likely to conceal the child, flee the jurisdiction with the child, or, by flight or concealment, evade the authority of the law. 2. There is no lawful custodian available to take the custody of the child. 3. There are conflicting custody orders or conflicting claims to custody, and the parties cannot agree which party should take custody of the child. 4. The child is the victim of an abduction.
Children taken into temporary custody under this section shall not be released by the officer in the field under any circumstances. The child will be released to the Department of Children and Family Services. As an officer, it is your duty to uphold the law if a criminal act in a child custody situation is present. Knowing, and most importantly, understanding the laws that pertain to these types of calls is critical for a positive outcome. Handling these calls correctly and providing accurate reports to agencies can greatly reduce the harm and abuse children will suffer. When children become the focal point of a custody dispute, no one wins.